Hi everyone, and you're very welcome to today's webinar. For those of you who have just joined, we've already completed the sound check, so thank you to everyone who helped out with that. If you do need to increase the volume, you should be able to increase the volume on your computer. So today's webinar is being recorded, and we will send a link to the recording of the webinar to all attendees afterwards. As for the presentation slides, we'll also include these in the email, but you can download them now at the moment at the right of your screen on the control panel in the handout section. You can just click on the PowerPoint there. Also on the control panel is our questions tab, so if you do have any questions throughout the webinar, feel free to type them in here, and we'll have a Q&A session for about 10 minutes at the end of the webinar, and we'll try to get through as many questions as possible. So we have two presenters on today's webinar. We have Michelle Arkins and Laura Murphy. So we'll have the webcam on for some of the webinar, but we will turn it off when Michelle is doing the demo so that you can see the Bright Contracts software in full screen mode. So I'd now like to pass you over to Laura so she can kick off for today. Thank you.
Thank you very much, Rachel, and thank you everybody for attending the webinar today. As Rachel said, I'm going to give you, I'm going to look at contracts of employment, and I'm just going to look at some key points that you might need to know, and then I'm going to pass you over to Michelle, who will show you a simple solution to managing contracts of employment in your workplace for your staff. And as Rachel said, we'll gladly take any questions you have at the end. I've set out the agenda there for you as well. But just before we start, I suppose in terms of contracts of employment and the employee-employer relationship, your contract of employment really is the most important thing that you will ever deal with. It really is the foundation stone of your employee-employer relationship. So I really can't reiterate enough how important it is for employers to get their contracts right and to get them in place. Not only will it clarify certain conditions for your employees, but for you, the employer, it will offer you further protection, and it really will be your go-to guide in the event of a dispute. Actually, since putting up this webinar and since we've advertised it, contracts of employment have actually come into the spotlight in Ireland, and it's very much on the employment law agenda and on the government's table. So it really is a topical issue at the moment that you're tuning into. Just to give you a little bit of an idea of where we're coming from, I suppose, a lot of you are probably Thesaurus software customers, and a few years ago when we started talking to our Thesaurus customers about contracts of employment, a lot of whom are small employers, what we soon learned was that there seemed to be a lot of confusion amongst Irish employers when it comes to the contract of employment. Now I've listed some of the the feedback and the queries, the questions and misconceptions that we got from our customers, and I've listed them here, and maybe some of you yourselves may be familiar or have the same queries yourself. So whilst the importance of contracts cannot be stressed enough, they really shouldn't be something that employers fear or dread, and they really shouldn't be. So our goal today, and I suppose our goal with Bright Contracts, is to simplify the contract of employment for you and to make it accessible for small employers. So hopefully in the course of today we will do that, and we'll help to dispel any misconceptions that are out there. So to move on, first and foremost, really the most important thing when you're looking at a contract of employment, it is that it actually is a legal requirement. And it's a legal requirement for employers to have contracts or to have written statement of terms and conditions of employment in place for their employees. And I say all employees here. So when I say all employees, I'm talking about your full-time employees, your part-time employees. Perhaps you have students or evening staff who are doing a couple of hours in the evenings or coming in every Saturday. Although they're only doing a few hours, they're fully entitled to contracts as well. Your short-term, fixed-term workers, maybe you have somebody coming in on holiday cover, somebody coming in now over the Christmas period to help you out. They're going to need to have contracts in place as well. And also your casual workers, maybe the person who helps you out when you're busy, who comes in as and when you need them, and you know, it might be only a few hours here and there, but they should have contracts in place as well. So everybody really needs to have them. And not only is it a legal obligation to put them in place, legislation also states that you must put them in place within 2 months of an employee starting employment with you. Now, from my point of view from consulting with employers, I would always recommend that employers put contracts out either before an employee starts or on their first day. And this really helps to set the tone of the relationship, and if there are any queries before an employee starts, this is really a good time to get them sorted. Also, in addition to that, legislation does say that employees must be issued with a disciplinary procedure within 20 days of starting employment. And what the disciplinary procedure sets out is the details of a dismissal, so how in the event that an employer needs to dismiss an employee, how they would go about that, and that's really what legislation wants employers or employees to receive. So again, legislation does specify this, and generally the disciplinary procedure would be given with your contract of employment. So I think this is another argument as to why to give that contract of employment earlier rather than getting closer to that 2-month deadline. And finally, just on this point, an important point as well, existing employees do also have the right to a contract of employment. And if you don't have contracts in place for your existing staff, I would say really get them in place, and it's never too late to have your contracts in place for your existing staff. And you really want to do it now before an issue arises. And how you manage, if and when an employee issue arises, how you manage that case will really be so much easier for you if you have documentation in place to support you and for you to be able to refer back to that when you're managing that case. And we see it all the time here on our helpline. Employers, they put contracts on the long finger, they say, oh, it's never going to happen to me, and next thing they're on the phone to us and they have a case, and it's more difficult for them to manage that because they don't have the documentation in place. And just on that as well, your existing employee can actually request from you that they would like a contract of employment. And when and if they did, you will have a 2-month time period in which to honour that request as well. So that's just to give you a bit of a feel for that. Looking then at the cost of non-compliance and the cost of not putting a contract in place, fines are enforced by the WRC, the Workplace Relations Commission, and if they find that you don't have contracts in place, they can fine you 4 weeks' pay per employee. Now, I've done some very basic calculations, but just to give you a feel for that, if you had 10 employees earning an average of 500 per week, you could be facing fines of 20,000. So I know a lot of the small employers that we deal with when we talk to, 20,000 would be quite a lot to swallow in terms of their annual turnover as well. And there is a mindset amongst some employers that, oh, well, this will never happen to me. But the reality is that random spot checks do happen, and they do take place in employers and businesses and Irish businesses. Previously, these were carried out by NERA. I'm sure some of you are familiar with NERA and the term NERA. NERA now falls under the Workplace Relations Commission, and inspections are carried out by workplace relation inspectors. So it's very much the same approach to NERA, although the inspectors now have increased powers, and they can actually issue on-the-spot fines as opposed to previously where a process would have had to be followed. So you'd be risking on-the-spot fines as well, but not having contracts in place. And just to give you a little idea about how many spot checks take place, last year in 2014, NERA carried out 5,600 random workplace inspections across Ireland. And again, it was a whole variety. There was no particular one industry or organisation. There was no rhyme or reason. They were pretty much random if you look at the companies that they looked at as well. Just moving on as well, failure to have proper contracts in place not only leaves you open to the costly fine that we talked about, but it also leaves you open to costly disputes which can escalate into tribunals, and then also you're looking at expensive legal fees in terms of representing your company. Not having clearly documented terms can really leave you open as an employer. So when we look at the agreement between an employer and an employee, it is usually made up of 2 types of terms. Your express terms, which are those that are written down, they're in writing, they're in your contract of employment. But secondly, then you have your implied terms, and these are unwritten terms, and they tend to have developed over time. And when we talk about a term that has developed over time, we talk about custom and practice. Custom and practice is a practice that has developed over an extended period of time by an arrangement that has really never been specifically agreed upon by either party, but could be argued that because it has been in existence for so long that it is actually forming part of the employee's terms and conditions of employment. The issue with these custom and practice terms is that they often can lead to disagreement between your employees and your employers with regard to, well, what actually was involved or what actually do they entail. And I've set out a recent case study here just to give you an example of that. It was a publishing company. And previously this publishing company, they had issued bonuses every year, Christmas bonuses to their staff. And then in the recent downturn that we've had, they decided that they weren't in a position to pay the bonuses. They couldn't afford to pay the bonus. The staff took the employer they took a case against the employer, and the staff claimed that due to custom and practice, the bonus had been an implied term of their employment and that the bonus should be paid. There was never any kind of written documentation on any of this. The employer argued that the bonus was discretionary and was only paid ever, as a discretion. It was always at their discretion. However, at the tribunal found in favour of the employees, and they said that because custom and practice had built up, that the bonus had to be paid. So that just gives you an idea of what protection that you can receive if you're going to put in contracts of employment in place. And we would always recommend putting a bonus policy in your contract to say that if bonuses are paid, they're at the discretion of manager. And if that company had that clause in, they could well have easily got away with, avoided this tribunal and avoided having paid bonuses during that difficult time for them. Just another case actually that came upon my desk this morning on our employment helpline. It was somebody who's using Bright Contracts now, and a company operating in the Meath region, a small employer. But a few years ago, he was operating, he had a few employees, it was all going very nicely. He thought, well, I'm never going to have a tribunal case, that won't happen to me. But the long and the short of it was that unfortunately he found himself in front of an employment tribunal, and he had to hire legal aid or legal assistance, which was costly in itself. But they developed their defence case. But on the day when they went into the tribunal, the tribunal said, well, where's your contract of employment? Where's your staff handbook? Where's any training policies and procedures that you have? And he, regardless that he had the defence case, he didn't have a contract of employment in place. And he told me this morning that they didn't even want to hear his defence case, and he was fined €20,000 at the time. And he told me that 20,000 is still raw with him today. So, if you're a small employer with small turnover, that is really going to be a difficult fee to swallow, as I said. So just to move on, pardon me, I'll just get a drink of water. I want to look briefly at the different types of contracts, and the type of contract that you issue an employee will really depend on their working arrangement, and it's very normal for different employees within an organisation to have different contracts in place. And just to go over them briefly, you've got your permanent contracts. Majority of employees tend to be on a permanent contract, and it can also be termed an indefinite duration contract as well. And this is generally where there is no end date specified. You plan that this employee is going to be with you for the foreseeable future. Permanent contracts don't have to be just full-time employees. It can also be part-time employees. If you have somebody working maybe 4 days a week or just mornings, essentially they're a part-time permanent employee, so they will receive a permanent contract as well. You also have fixed-term contracts. So this is if a person is being employed for a limited but defined period. You might be taking somebody on for a 6-month contract, so there's an end date in mind. You have specific purpose contracts, similar to your fixed-term contract, but your person's being employed for a purpose, so there's really no end date set at the time of hiring them. So I suppose a good example would be perhaps maternity cover. So you're not exactly sure when your worker is going to return from her maternity leave, so it's kind of an open-ended, but it's a specific purpose contract. You have temporary contracts as well, and again these are very similar to your fixed term. There tends to be an end date in mind here. The final two types of contracts are your casual contracts and your 0-hour contracts. These are the two types of contracts that are really in the news at the moment. Only recently, Minister Jed Nash, he put out a tender for an investigation, I suppose, into the use of these type of contracts in Ireland, just to see how they're used, what employers are using them. I suppose they've come to light. Some of you might be familiar with Dunnes Stores. I've had a few recent cases where a lot of the Dunnes Stores employees are on or on casual contracts or 0-hour contracts. So they are used by employers who perhaps can't offer fixed hours, and they're used, for people to be able to be available to them as and when. And definitely from an employment point of view, there's definitely a place for them. And a lot of employers, particularly small employers, whether they're in the retail or hospitality industry, that tends to be where they are used more. But these type of contracts are a saving grace, because they offer employers that kind of flexibility to be able to hire as and when you need it. There is the counter argument that it puts employees in a very difficult position in terms of having to have a guaranteed wage. So there's that fine line, and it's definitely something that the government are looking at the moment. It's actually currently at consultation. I would expect we'll really see kind of some changes or some new legislation coming in early next year, but it's definitely one to watch, I suppose. But for the moment, they're there, you're able to use them, and they do offer flexibility. This type of area, the types of contract we do get a lot of questions on this on our helpline, and we would definitely guide employers over which contract should you use for different employees. There are no hard and fast answers, and definitely when you're looking at the type of contract, the type of contract that you will choose will very much be based on a case-by-case basis, and we will definitely look at the scenario and the situation that you have in terms of deciding that contract. Just to move on then, I want to look briefly at what is actually going to be in your contract of employment. We talked about the legal obligation, but along with the legal obligation of having a contract of employment, the terms of the Employment Act also states that there is certain information that you need to have in your contract of employment. So I've listed that out here for you. I won't go into them all, but I suppose just to touch on a couple of them, you're going to need to put in the address of the employer. So that tends to be your registered address, your head office, if you like. The place of work, then, that can obviously differ if somebody's working at a different site than your registered office. But also in cases, obviously a lot of employees don't have a fixed place of work, and they're on the road, they're going to different clients, and that's perfectly acceptable. It's just that you need to specify that in the contract. You'll put details of the job, duration. That would again generally be for your fixed term contracts that we spoke about earlier, or your temporary contracts. You put in a duration, and you'd have to put in an end date or expected end date as well. You'd put in details of their pay, any sick pay that they'd be entitled to, and notice that an employee would have to give an employee on termination, and vice versa, that the employer would have to give an employee if termination was to occur. So they're the things that you have to put in by law. But in addition to that, in addition to your statutory minimum requirements, it is highly recommended that employers include additional extra terms in the contract, and these will really provide further clarity to your employee, but also protect the employer and give them that fallback. Exactly what additional clauses you put in will very much depend on the role. Different roles in the company will have different clauses, absolutely. Your company, what your company is doing, your situation, and the business that you're in terms of having to compete with other competitors. I've just listed a few here again that we recommend, and our bright contracts would include some of these by default. Probation policy, definitely really highly recommended. It really helps you manage a new employee. Confidentiality clause, should I say, and again, you might have staff who have access to confidential sales figures, customer data, so it's really key that you'd have a confidentiality clause in there. Your layoff, short-term working, time and attendance, post-termination restrictions. That is a clause, again, I suppose to give you an example of where that might be used is perhaps in pharmacies. I know it's a small market in Ireland, so a lot of pharmacies would put a post-termination restriction in for their pharmacists that would prevent them opening up or working for a competitor for a certain period of time after they leave employment, because it adds that added protection for you as an employer. And reference to company rules and norms, and this one I just want to kind of touch on, because in the contract you can refer employers to other policies, and you can refer them to your company handbook where they can find details on other terms and conditions of employment, and whether that is your dress code or your email policy. And my advice really is to keep your contract as lean and as simple as possible. You don't want to overcomplicate it, and it's perfectly acceptable to have other policies in your company handbook which will equally hold as much weight and importance, but are not needed in the contract of employment. So as you can see from this and the previous slide, there really is a considerable amount of information that you should have in your contract of employment. And if employers want to be able to stand over their contracts, and they want to be confident that these are going to stand up in a court of law or in a tribunal, it really is highly advised that you do seek external professional advice when you're putting them in place. So very briefly then, I know I touched on company handbooks briefly, and I just wanted to expand on this a little bit more. The company handbook can really be, given out, and it goes hand in hand with your contract of employment, and it can be called staff handbook, employee handbook. So it will be generally, we would advise that it is issued in conjunction with your contract of employment. It'll set the tone of your organisation. It will outline standards of conduct, safety, company regulations. It'll inform your employees of the terms and conditions of employment, your policies, your rules. We spoke about the dress code, your social media policy, what behaviour is acceptable, what behaviour is unacceptable. It's also a really useful guide for your employers and your managers, and it'll be a reference point for your managers in dealing with different situations that come to them. Your company handbook does need to be reviewed regularly. This year alone, I suppose, with legislation changes in Ireland, we had a whistleblower policy, and we had changes to absence policies that came through legislation. So they really need to be updated in your company handbook as well. And finally, your company handbook should be accessible to all. It shouldn't be something that's put in a drawer. It should be there. It should be referred to. It should have nice dogged ears or whatever it may be, but it should be used. I've given a brief outline of the type of data that will be, or type of content that will be in your company handbook, but I know Michelle is going to touch on this in more detail, so rather than kind of repeat ourselves, what I'll do is I'll pass you over now to Michelle to get going with her demo on Bright Contracts.
That's great. Thanks, Laura. If you just let me begin by saying that Bright Contracts is designed for everyone. It's not just for large companies with dedicated HR departments. Like, it was designed specifically for small to medium-sized employers, like, who wish to carry out this function and legal obligation in-house on their own PC without the need or expense of HR consultants or employment law solicitors. And what's really clever about the software is it keeps the whole process of creating contracts and staff handbooks really simple. In that respect, it's totally unique to Ireland and the UK. So I suppose we'll start off the demo by focusing on our Employee and Contracts tab just up at the top of the screen here, just the fourth one across. And this is what we're going to go into to have a quick look at our employees. So you can see on the left-hand side here we have the employees that are with us today, and they're very easily imported up here to the File button to our import and export data. So if you have Thesaurus payroll or anything like that, you can just come straight in, or you can import them through a CSV file. So it just simplifies things and speeds the process up. So if we go, let's say, to our most recent employee, Amy Kane, and we click on her there, you see now. We go into employee details. So here we have Amy, and she would have joined us, let's say, just recently there in October. And what we want to do with Amy is give her a new contract. So it's only a matter of simply going up to the buttons up the top here and click on New Contract. And there's a text box that'll open up. The first will obviously be our default contract settings, and the second would be to use from an existing contract. Now, this is very easy to do. So once you've literally set up a few of our employees, for example, if Amy was in the same position and had more or less the same job description as Harry, we could just click on Harry's contract and just work away from there, which is very, very quick to set up. But for the purpose of this exercise, we'll stay with the default contract settings that you'll get from day one. So what happens is then it opens up the screen here, which contains 6 main tabs that run right across. So all literally we need to do in order to set up the contract is just go through a series of questions and input the relevant information. So we just need to answer them basically. So the employee first, we have obviously Amy's name, her address, and we can put in the date of birth. Again, we do that in all kind of situations if Amy's under the age of 18. And again, you've little snippets of information located on the right that you can use at all stages. And that gives you a very good outline of the reasoning why this is in the contract, why it's important, and why we'll fill it in. So in this instance, Amy's not 18, so I don't have to worry about it. So we'll leave that out. Now we'll just put in Amy's job title. So Amy is just going to be an office assistant, so we'll just put that in there. And then we can put in a job description if we like, or in the case we can just copy the little section that's here. And this is where we're just stating that our job description will be attached as an appendice to this document, so we'll leave it at that. Amy's rate of pay would be €10 per hour, so that's fine, we'll leave it at that. She's paid weekly by credit transfer. Now, we just save that and move across. So into dates and places, the date of this contract is obviously today, the 26th of November, and the commencement date, Amy would have joined us on the 20th of October. So just input the date there. The commencement of period of continuous employment, again, we would fill this in if Amy maybe worked for us in another company or elsewhere and then transferred into our company here today, but that's not the case. So therefore it's not relevant. Now Amy, again, because she only started with us last month, she's going to be on the probationary period. So for the practice, we're going to leave it at 6 months here, and we can extend it obviously depending on her performance as we assess her along the way. So we obviously keep that box ticked on the probationary period. The place of work, she'll be on Dublin Road, Ashbourne, County Meath. And we just need to tick these boxes again if any of these are applicable to Amy. So if she's required to drive, no, and either if she's expected to work elsewhere, no, we don't have a second office. And if she may be required to work outside the state for a period of more than 1 month. So none of these are relevant, so we'll leave them be. Then we move into our contract type and hours. We're going to be giving Amy a permanent contract, so that's perfect. She's going to be working normal hours at 37.5. But our start time will be 8 a.m. to 4:30. And then if we have any exceptions, and actually she works Tuesday to Saturday as opposed to Monday to Friday, and if we want to, put exceptions to the normal hours, we can say that she may be required to work, Mondays in periods of staff holidays or staff shortages, or, if there's any busy periods. And we'd also include if there's any collective agreements that would actually go into that text box. And again, if you're unsure on anything, just click down the little snippet aside with the information there and it'll tell you what it's about. Now we'll save changes and move across then into our overtime, holiday and other pay. So here we want to see if there's overtime, whether it's paid or unpaid. So for the purpose of Amy, it's going to be unpaid. And whether we've any details on the overtime or remuneration arrangement. So if you have any bonuses or anything that need to kind of go into this section, or health insurance, commission, car allowance, anything like that, we can just enter it up there into the little text box. And then we have accommodation provided. Again, it's not relevant in Amy's case, and we can see again why we might include that. The annual leave days will leave at 20 because of the hours she'll be working over the 1,365 in the year. But if it was a case that Amy was working part-time, you would just default that to 0, and then the contract would literally stipulate what she would be owed, like the 8% of all hours worked, 1/3 of a working week, so on. Our annual leave year, 1st of January to 31st, that's perfect, I don't need to change that. And she will be paid in lieu of notice in the event of a termination, so that's just something we wish to put into the contract also. We don't have a sick leave, a specific sick leave policy, so for the purpose of that, again, there's no sick pay arrangement, so we don't need to use it either. So let's save our changes and move off into the Miscellaneous tab. Rest breaks are unpaid, and the rest break, obviously, period that we're happy to give will be the 60 minutes because of the hours of work. So she normally take her rest break between 1 and 2. And then we just have to look at the area of the notice that's required for termination. So in this case, yeah, we're happy enough for 1 week. So if she's to leave our employment, as long as she gives us the 1 week's notice, that's fine. And also if she's out if she's going to be sick or anything like that, on absence of, over the 2 days, we would require a doctor's certificate. So we'll leave the 2 days in. And in all instances, again, you can change this, there's no problem. And the minimum required notice, if, let's say, she won't be attending on any particular day, I would like to at least perhaps get 3 hours. So I'll just change that. And then the notice of absence requirements. Again, this is an important one to put into a contract because there's a lot of complaints that kind of come in where, the social media is being used an awful lot to inform the company, whether it be through Facebook or Twitter or LinkedIn accounts. So sometimes it just might be necessary to put in to inform the company that you're required to contact your manager directly by phone. So we'll just put that in. Retirement age, I suppose we'll leave it at 66 for now. And whether or not we have a pension scheme in place, again, we don't have here, but we do have a PRSA provider. Again, it's something that you need to be thinking about. If you don't have one, you must have the other. So we'll just put in AIB Bank, we know is our PRSA provider. So that's perfect. And we'll save the changes. And then the very last tab is our additional tab. And this is where you'll be able to go in to view the sample additional content that we have available online for you. So if we just take a quick look there, we can have, we'll just comes down, perfect, what we might include here. So for argument's sake, I would say an important area will be like deductions from wages. And all you would simply do is go in and just copy, go back into our software. We're going to add a new section to the contract, title, and put it in, that's perfect. And then we'll go back into our deductions. And this is where we'll be stipulating that the company may at any time during or at termination of your employment deduct from your salary and or other sums due to you. So it's just, again, another clause that's very important to use if, for argument's sake, you may have overpaid them or anything like that. So we'll add that clause. And then you can, again, this can just continue on to see is there anything else. Confidential information, again, is another good piece to have. Another good clause. We'll just go back in and enter it in. Now, so that it's a likely part of the job that she'll have access to confidential information, so we just want to make sure that that's kept in-house. Yeah. And so on and so forth, and you continue like that and add as many sections. So for argument's sake, I mean, if I even looked at the likes of Bernie King, you're able to have a look at Bernie's contracting, you'll see then with the areas in the additional, like we've included about 6 or 7 of them there. So that's literally how easy it is to do. And then any situation just with Amy and Amy's new contract, I can just go up to the top here and preview it. And literally that is how simple it is to complete the contract. I've also personalized it by putting my own company logo and the company name here, which is really easy to do from the software. And you literally just kind of read down the contract and just make sure that you're happy with all its terms and conditions that you've put in, that the rate of pay is correct, her holiday leave, her job description, whatever she's going to be entitled to. And you literally, that's exactly what you would do. So that's perfect. Then you can just go up to the top and you would print 2 copies and then you're ready to go with the contract. Now, that's really, it's very, if you look even at the top, it's very simple to amend styles and fonts if you want to do the header and footer and even the page setup. And then you have also, if you wanted to delete, preview, print, export it as a PDF or export it as an XPS. And that'll always stay within our software. So as I say, that's how quick it is and easy for the contract. We'll just move over to the left here and we have our handbook. I'll just show you very quickly. Now the great thing about our handbook is the fact that it's literally sitting there ready and waiting, and it's 37 pages long and includes all of the valuable policies and procedures that you need Legally, as Laura had touched on earlier on with the grievance and disciplinary, because that obviously needs to be issued within the 28 days of the employee starting, even ahead, believe it or not, of the contract. And as she outlined very clearly that, again, it's if the employee has a grievance with you and wishes to leave, or equally if there's a disciplinary matter from the employer, what the process entails and how it will be followed. And this is why it's extremely important, if you have policies and procedures in-house, that you follow them. That there's no point kind of going into an employment tribunal or sitting in front of an adjudicator now and literally kind of having these wonderful policies but not having conducted it properly at all. So again, we give the full outline in all our procedures on the reason why they're there, and if you wish to conduct investigations, appeals, disciplinaries, anything like that, you can just go along. We also have, if we look down, the bullying harassment policy. And again, the same things outlined, all the areas kind of covering harassment, sexual harassment, bullying, lack of respect, the procedures again to be followed if you do it from an informal or formal investigation outcome. So it's really great guidance notes to the employer as well. We touch on then the health and safety policies, equality policies, obviously covering all the 9 grounds of discrimination, our terms and conditions, with our probationary policies, hours of work. Now the terms and conditions in our handbook are really useful from the respect that if we want to, and which is always best practice, like to keep your contract small, we want to make sure if there's anything we wish to elaborate on, we'll do so in the handbook. So the great thing about our handbook is you literally, in any situation, if we said for argument's sake we wanted to go into the hours of work and change anything, we can just go over into the right hand side into edit this section, and we can literally open up as a Word document, and then you're free to add in maybe existing policies or anything that you have in-house, whatever it is you want to write, and include them all in there. And you can just see, look, if you go down a little bit further, then we kind of, we're bringing in hygiene, dress codes, alcohol and drugs, confidentiality again, right to search, resignation, termination. I mean, there's just a wealth of information there for you, and also policies that you can include. Like there's a very important one again with the CCTV. You know that it's very important if you're going to use CCTV in a disciplinary process that you must have notified your employees when they started with you that, again, it was an operation, and obviously it's going to be there for health and safety reasons, but if you did wish to rely on it in court or through any instance of a termination, that you need to make sure that they were aware that it existed, that they're not covert cameras. And then if you have personal mobile phones, again, this is one that's touching all the time for a lot of employers, where staffing are constantly on the mobile phones because they've access now to their LinkedIn profiles or emails, text messaging, so it's very disruptive. So again, you can put a full policy in there and reference letters. We obviously outline all the different leave and benefits, like your annual leave, public holidays, maternity leave, paternity, parental, force majeure, and again, great reference guide for managers, employers to have a look at anything that they feel or maybe feel a bit unsure. So always remember, like if an employee comes up with a request, you can always just basically tell them that, yeah, leave that with me, I'll come back to you. Go in and have a little read of what you have, and then you can come back kind of with your answer. And then we also at the very end of your handbook touch again on your pension policy and plan. So if there's anything additional you want to enter in there, again, you can. So up the top you can have a look, you can add a new section if there's something not in the handbook that maybe it's a policy you have in your workplace at the moment. So it's very easy just to add a new section. We can reorder our handbook. We can print an individual section, so if something, for argument's sake, is updated, we can just go in and just print that particular section, which is very easy then to give out to all our employees, or export as a PDF, so we can send it to them as an email. And then we have optional sections we can include if we want, we can delete, and that's an important thing. So even though the handbook is just sitting there, if there's anything in it that you don't wish to use, for argument's sake, maybe you've application information and you didn't think it was relevant, you can just go up and delete the section, press yes, and it's not like it goes anywhere that you'll never be able to use it or bring it back again. It just sits inside our optional section tab again up the top there. So that's perfect. And again, we can have a look at our cover page if we want to kind of change headers or footers or the size of anything. And then we have our styles and fonts, our headers and footers, our signature page. And this is very important because if we have a look here, even if I do absolutely nothing to the handbook, it's perfect. It's literally sitting there ready to be printed. And then we've 36 pages. So all I would literally need to do in that instance is obviously read it, make sure it's relevant and applicable to my business, and I could just export it then to all my employees as a PDF document to their email addresses, and then just print one copy and leave it in-house, and then make the relevant changes as we update it throughout the year. So it's a very, very simple process to do. And then when you give kind of, a good opportunity for your employees to read it, they can sign off then, and all we need to do is go up here into our signature page, where it states that we can either do a separate signature page for each employee, or maybe on a particular day that they're in for training or a staff meeting, you can get them then to sign off and with their name, signature and their date, and in that way that they've acknowledged that they've received a copy of and understand the contents of Bright HR Limited Employee Handbook. So you'll be able to keep that on file, which is very good. And the same thing applies to your contracts. You can just print it out, export as an XPS or a PDF. And that's literally what sits in our handbook. Our employer tab is pretty much simple. It's just an area where we can go in here and put in our company logo, so we can personalize our contracts and our handbook. And then we can just, obviously we have an outline of our registered employer name and the address. And we also have an area for our JLC agreements. Again, I know a lot of them aren't applicable, but they're starting to bring a lot of EROs and stuff like that back now for the security and domestic cleaning industries. So it's just something to be very mindful of, that they will be coming, I'm sure, to the forefront at some stage, but we have that area available for employers. And then our summary tab, which is really clever, because what it does is you'll be able to find a full overview status of all your employees. So at a glance you can see areas such as the handbook versions that are in use. We have down here then the most recently updated section. So again, I've been playing around a bit, with the software, just to give you an example of when you are making changes, that this is kind of how the overview will look for you. So we've just kind of included with the absence and sick leave, as Laura spoke about earlier, where employees are now on certified sick leave, they can accrue holidays and bank holidays. So that was updated on the 20th of the 8th, and then amendments were made to our introduction, our CCTV policy and our hours of work. So again, it just shows. And then we have a look here, we have 14 employees in total, and it's telling me that I have 2 that have no current handbook. I also have a good few here with no signed contract, so that's something I need to kind of get on to straight away. I have 2 that have an out-of-date handbook because they wouldn't have been given the most recent policy when we changed it. So again, that's something that I'll need to address. And then I also have, which is very important, 2 employees that it's flagging for me also that they have expiring contracts. So if they're on the fixed term contracts, that's something, again, we need to deal with promptly. We don't want them working over the end date of the fixed term contract without us being able to issue them with a new fixed term contract if there's a role in the company for them. So you'll just see a little kind of donut wheel on the right hand side where it just gives you the quick synopsis of what's kind of happening within the company. And then I'll just briefly go to the file tab we have up at the top left hand corner, and at all stages this is where the area that we can import, export the data, we can change our password, and that's a great thing about Bright Contracts as well. It's secured and locked down, so nobody else in the company can get in and access it or change anything as well. And you can have different passwords for different personnel also within the company. We have a snapshot, so when all our information is up and it's ready, we'll make sure that we will download all that information onto a USB key or an external hard drive. So if anything happened, let's say to our laptop or the computer in work, we'd just be able to download Bright Contracts again onto another computer, put in the USB or download it from the external hard drive, and all our information is back up and ready. And we also have just different preferences again that we can use if you want to just change in the way things are displayed. Now, the very important part also with Bright Contracts, not only just with the software side of it, is that we have a wealth of support documentation that it is very valuable to employers. So if you kind of look up here in our Quick Start Guide, you're able to go in and have a look at template HR documents there, that if you needed anything for sample offers of employment letters, parental leave forms, force majeure leave, probation letters, sample whistleblowing policies, additional contract clauses, there's just a lot that you can use. And there's also like a lot of kind of HR guidance as well. So it goes a great overview of all the codes of practices that are out at the moment, like with the labour court. So you really get a good feel of the law, the employment law as it stands, and the reasoning for everything. So it's a great thing just if you ever had the opportunity just to go through it and read it. So there is a lot of support that side of it online, and that we'd also provide, obviously complementing the software, would be the initial software setup. So we'd ensure that any user of Bright Contracts right from the start is very, very happy and conversant in using the software and setting up their contracts and employee, and you can go ahead and ask as many questions. We also, as you know, look after webinars and newsletters. We provide technical support And we also, the most importantly, have a dedicated employee relations support advisor team in-house here. So if you're going through anything, we're able to look after all of that for you. So there's no problem at all with any queries or questions that you have, or anything indeed if you're facing at the moment, with any of your employees. You can just simply contact the support team and we can walk you through absolutely everything and give you additional template documents or letters or anything that you need throughout whatever the process is. Because as again I say, we can give you good advice, bullying, harassment, redundancy, termination, so on and so forth. So that nearly kind of brings me to conclusion really with the software side of it. And I suppose an important aspect, as we all like to ask, is really, the cost of the latter. And the software and support for a single company for unlimited employees costs €399 for a standard license for a 12-month period. However, obviously for today, we're very happy to offer an exclusive discount of 25% to all attendees who would like, if they feel it's something that would really work for their company if they wish to purchase before 2016. So that really brings me to a close. I think I've done enough talking now at this stage. So we might go ahead and start having a look at some of the questions that are coming through. There's quite a few. So we'll do our best to get through as many as we can. That's brilliant.
Perfect.
Thank you.
I'll give you a break, Michelle.
That's lovely.
Thank you. We have a question coming in. For seasonal work, can you issue fixed-term contracts each year, or is there a limit to the number of fixed-term contracts that you can offer to the same employee? There is a limit when it comes to fixed-term contracts, but that limit is to consecutive contracts. So if you have an individual on consecutive working straight away afterwards, essentially they can't be on a fixed-term contract for more than 4 years. If I'm understanding the question right, and it's just somebody who's coming in for seasonal work, perhaps they're working every month of December, let's say, that's fine. There's no limit there. Essentially, once there's a significant break between the two fixed-term contracts, they'll be very much seen as two independent contracts with no link of service, I suppose. So the key thing is, once it's not consecutive and there's a significant break, then there's no limit and you're fine. Once you're getting into consecutive fixed-term contracts, then you have to be a little bit more concerned. So I don't think there's anything to worry about there for that question. Just looking at some of the other questions coming in. What start date should I use if I'm creating a contract of employment for an existing employee? This is a really good question, actually, and we get asked it a lot. Obviously, let's say you have an employee who's been with you for the last 2 years and you think, right, now is the time to get the contract in place. You want to always honour their service. It's very, very important that you honour their service. So in their contract of employment, their start date, it would be very, very important that you put their start date as the date 2 years ago rather than the date that you were issuing the contract. It's very important to that you're giving them that service, because that will affect a whole range of different I'm lost for a word here, different things that they might be entitled to in terms of redundancy payment and things like that. So it's very, very important always to honour somebody's service. Do you want to take the next one?
Yeah, just the next question there, just do I need to give everyone a hard copy of the staff handbook? Again, I mean, this is something that actually normally does crop up when we talk about handbooks, because a lot of employers kind of feel, well, it's not a legal document, so, is there a necessity to give a hard copy? Well, as we said earlier on and throughout the demo, I mean, the best way of doing it is you want to just make sure that they have the copy of the handbook, because obviously all your important policies and procedures, and especially the one that you're, obliged to give them, the grievance, the disciplinary. So it's just really, I suppose, from a point of view, you can just email the soft copy through to your employees and keep the hard copy in-house. So as long as they have access to it, and that you make sure that you refer to a lot of your policies, there's no problem. It's not necessarily that you have to go printing out 50, 60 handbooks and hand them out personally. I honestly would just put it through an email and have the one hard copy then in-house. And another important thing, actually, I know I'm touching on another question that might be there, but again, as Laura said earlier on as well, it's kind of more or less like a company safety statement. It's a working document. It's not something that you just print up, have, sitting on your shelf that looks pretty that you can use, if in a grievance or a disciplinary case. It's something you need to be going back and referring to all the time, and to make amendments and make changes, not only when legislation changes, but even with best practice and case law. And that's something that also we look after, with making sure once the updates come in from legislation, it's fed straight into your software, so you're always kept up to date and you're able to change and make sure that you have the most relevant up-to-date knowledge. But that you do refer to it, and even have a type of an annual review with your staff. So if there's any issues within the company, you can also turn around and say that, look, we would like you to refer to section 3.4 on our, our whatever policy it is that you want to talk about at the time that's very relevant, like your mobile phone policy, or if there was, anything going on at the company. You just make sure that you're constantly reviewing it all the time and making your employees aware of it, because there's always those cases, again, that we've seen time and time again in employment tribunals where, oh, we gave out the handbook and that's fantastic, and how long is your employee in your employment? Oh, they're with us 6 years. And then it's a case of, have you ever reviewed your handbook? Has your employee ever seen it since they started 6 years ago? And the answer from the employer would be no. And then the first thing the judge will always say is, well, would you remember everything? A 37-page document from 6 years ago. So again, it's just important that you keep reviewing the policies and letting your employees know about them. Sorry, Laura, do you want to go ahead and take the next?
Yeah, another question we get asked a lot, and people say, oh yes, the software's great, it's the answer to my problems, but the problem is I've got my employee has been in here for 5 years. How do I now go about actually rolling out a contract of employment? As we saw, we've come up against that before, and we get comments saying, oh no, my employees are here a long time, I wouldn't even know where to start in terms of introducing contracts. And so absolutely, that is a query that we come up against a lot. And we've put together a lot of guidance and help on that, and a real step-by-step guide for employers as well in terms of how to approach that situation. And all that data is on our website in the support that Michelle showed earlier on. It's very much, I'm not to go into it step by step at the moment, but what I would say, and the key point I suppose, is it's very much open communication. You really want to be open with employees and explaining why you're putting this in. And the more open you are, and you have to be open to take questions, no problem, we'll take your questions, what is it? So it really is showing that you're not here trying to hide, or you're not trying to pull the wool over anybody's eyes or sneak in different terms. It's just that this is, you're complying, and this is a positive thing for you as an employee, because at least now that your employer is standing by the legislation and putting in everything in place to ensure you're working under the correct employment conditions. So absolutely, it's open communication. We have a step-by-step guide on the website, but in terms of customers using the software who then decide to go and roll it out to existing staff, if you get questions back from employees, come and ask us. We're more than happy to help you answer them and put together an answer to go through to put to an employee. And it's very much a process, but it's something not to be too worried about. Just a follow-up to that, there's a question that's come in. What action do I need to take if an employee refuses to sign a contract? Hopefully, and please God, if you've gone through the process and it's been open communication and you've dealt with questions, the ultimate aim is obviously that they will sign and you'll reach that agreement, and if there had been a query that you could iron out, you could get over it. From time to time there may be a sticky subject, or unfortunately it's to be honest, it's been very rare in my experience that I've come across where an employee will point blank refuse to sign a contract. But what I do say to employers in that situation is that ultimately the employee does not have to sign the contract. That's not the legal obligation. The legal obligation is for you, the employer, to give them the contract. By virtue of the fact that your employee is coming into work every day and is doing their work and accepting their pay at the end of the week or the end of the month or whatever it is, by virtue of that fact, essentially they are accepting the terms of it. So I wouldn't be too worried, although it's not the ideal situation. Once you have the contract in place, or have given it to them, that's the key point there.
Yeah, absolutely, and as long as it's just signed and dated by the employer, isn't it? Yeah, I know, because that's always a big panic. There's a lot of calls come in all the time with that. Yeah.
And I think if you can keep documentation to show that you've engaged with the employee, whether that is email saying, send me your question. So if you have proof, that's all going to back up your case, and that's the best thing that you can do there. So I just seen another question in there.
Oh yes, absolutely. I know, again, it's very, very relevant we're always asked about this. So you're looking just for more detail on the pension situation, that you said you had to provide a PRSA or a pension. Absolutely. Like an employer is obliged to, if you don't have a company pension scheme in place, then there must be the facility there to join a PRSA. So that's the personal retirement savings account. Again, you can get this pretty much from your local bank. They'll have all the booklets and the information there, or you can shop around and go to an individual broker, like, who'll come in free of charge and give you, you know, the best, let's say, pension scheme that's out and available at the moment for your employees, and he'll sign them all up. All you then have to do as an employer is just deduct the money from the employee to pay into the pension. That's all you're obliged to do. And again, same thing, if you don't have a pension scheme, a company pension scheme, it's no problem at all, but do have the PRSA instead, and obviously to make sure that all that information is available to all your employees to join. Now, whether if they don't join, again, there's no problem at all on that, but that you do have the relevant information there. So.
Yeah, it's not a major point, but again, it's something that has to be put in. That an employer has to give an employee access to the PRSA, and you have to accommodate that through your payroll, which of course, if you're using any of the software, will allow you to do that. And we kind of suggest that you put in a supplier, like Michelle said, like a bank. But you know, if you're small and if you just want to leave it up to the employee to find their own PRSA plan, that can happen. The one thing I would say is that because employees are entitled to have access to some sort of a pension scheme, they're allowed to do that in work time sometimes as well. So if somebody wanted to meet, I don't know, a broker or something, try and be as accommodating to that as possible. Again, it's just showing your reasonableness. It's not a major burden for employers, but it's just to be aware of it, I suppose.
Yeah, absolutely.
Yeah.
I don't know, we've quite a few of them there still left if you want to go through any more, do you?
Can I purchase the software just for the handbook? Absolutely, you can use you can use just the contracts, you can use the handbook. We advise using them in conjunction because, you know, some parts of the contract will refer to the handbook, but obviously you can absolutely use them for one or the other. That's no problem.
That's perfect. I'm going to just take one more because I know we won't get around to answering everybody's queries. But actually, there's an interesting one. Again, I got a phone call there again this week on it. That what happens if an employee walks out without giving the employer the required notice? What can the employer do? I suppose the honest truth is, I mean, it's a breach of contract. That's the first thing from the employee's point of view. But from the employer, unless you wish to kind of proceed, you know, with trying to sue the employee for breach of contract, it's more than likely going to cost you more headache and heartache with following it up. But I know it is something that we do get calls on and off all the time with, especially in cases where the position at hand is one that, you know, will require like a month's notice to fill that position. So when somebody like that walks out of your company, it's a tough thing. But I mean, you can tell them obviously that they're required to give you the 4 weeks notice as per the contract because of the length of service or the type of senior position that they may have. But really, if they walk, you know, as I say, the chances of you pursuing a breach of contract, probably it wouldn't be worth it. So sorry, I know that's probably not the answer you're looking for, but that's the reality. I think sometimes situation.
Lessons that relationship has come to an end, maybe.
Well, yeah, in a lot of cases, absolutely, yeah. Absolutely.
I'm just conscious of the time, so we're coming up on our hour, so I think we'll bring it to a close now. Just before we finish up, when you log out today, Rachel should have set up a questionnaire that you receive, and we'd really appreciate your feedback. It's really useful for us in terms of creating new content and more webinars going forward. So if you have 5 minutes or 2 minutes, it doesn't take that long at all, we'd really appreciate if you could fill that out. So otherwise, thank you very much for your time today. We hope you found it useful and informative, and hopefully we'll be seeing you all soon.
That's great. Thank you very much.